Orellana versus Town of Carmel.
Good afternoon, Your Honors. My name is Enoch Brady. I'm here on behalf of the appellant, Anna Orellana, today. Next to me is my appellate counsel, Marie Hadukovic. I'm asking for 5 minutes for rebuttal.
Yes.
We're asking that the Appellate Division Second Department decision be reversed and that the summary judgment motion of the plaintiff be granted because we feel that the 1103B exception was misapplied in granting the summary judgment motion for the Town of Carmel because defendant Simone was not actually engaged in work on a highway at the time of the accident, but in fact was traveling from a work site back to his base of operations.
As I understand it, counsel, both the Supreme Court and the Appellate Division held the opposite, right? And we would have to say, as a matter of law, that determination based on this record is incorrect.
Yes, that's exactly what we're asking.
And why, as a matter of law, looking at these facts, is that incorrect?
Because the facts, as testified to by defendant Simone, support the finding that he, in fact, was returning to his base of operations. On page 75 of the record, where I first...
So your position would be there's no support in the record at all for their conclusions of the two courts below? That would be the standard, right? There's no support in the record for the factual, basing that conclusion on these facts.
That is, in fact, what we're supporting. For instance, in the respondent's opposition brief, in 10 different places, they say that, in fact, the defendant, Simone, was actually continuing his inspection, was always inspecting, but in none of those 10 locations where they state that, do they cite anything in the defendant's transcript to support that?
Counsel, you make some arguments in the alternative in the brief, and I just want to try to get an idea of what you think the scope of the 1103 protection that was available to Mr. Simone was. So I want to ask you a hypothetical question. If this accident had happened somewhat earlier in the day when Simone was at the Kingsridge Road location, his bellwether location, and he had stopped his car at that particular location to really get a good appreciation for what the snow accumulation was there, and some sort of accident occurred. In your view, would he be able to invoke the protection of 1103, or is there something about the nature of the entire task that he was doing that disqualifies him from 1103 protection?
Well, that is certainly a different set of facts because the location that he was going to was, in fact, the Kingsridge and Prince intersection. And certainly if the accident had occurred there, that would be very different than the intersection where it occurred 5 minutes after he had already left that intersection. There would be a number of questions I would ask. For instance, while he was at Kingsridge and Prince, when the accident occurred, did it occur before or after he radioed into his base and he directed his 35 workers to go out and address the 28 different routes in town? If he had already made that radio call, that would certainly be an important factor to discuss.
But would you be willing, and you can say no, but would you be willing to concede that there might, it's not, what I'm getting at is it's not the nature of Mr. Simone's duties per se that disqualify him for 1103 under these facts. It's just what he was doing at the time of the accident that disqualifies him.
Yes, that's exactly correct, and that's what every court has had to do in every decision that's been cited in our brief. They had to actually look at what the individual was doing, the municipal employee was doing at the time of the accident. So certainly changing the location to the area that he said he was going to perform his inspection, Prince and Kingsridge, would certainly make it a more difficult case for the plaintiff in the sense that he was at the work location. However, that would not end the inquiry. You would still have to know exactly what he was doing, had he made the call to his base already or not, and whatever other factors may have existed at the time of your hypothetical.
And what if he had, upon his return, I understand there was an accident, but upon his return, put in an order for an additional snowplow to go to the area where he noticed the additional snow accumulating?
That would really not change the analysis in the sense that he would still have been at another work location. In other words, when he left his base, he was at a work location. He went to Kings Ridge and Prince, which was a work location, and he was ultimately heading back to another work location.
So is your view that if he is in the course of commuting, that he, returning to the office, that even if he sees something which is relevant to his duties and then later acts on it, that because he set out to return to the office, that it can't be covered?
And when you say covered, you mean covered by the 1103B
Yes.
exception?
Yes. I mean, he's
certainly-
he's out inspecting, right? He puts a call in, and I believe he says then that he was returning to the office at that point when the accident occurred, right? If he had, in fact, observed snow in the course of his return to the office and then acted upon it, would that be enough to trigger the coverage?
If he had acted upon it at the time he saw the snow, then
Okay,
that may
well,
have been different.
one might act on
But-
it a little bit later because you're driving your car and you're going to wait until you pull over or you get back to the office, but,
Well, the 1103B exception specifically talks about traveling. So if, in fact, he was just traveling between Kings Ridge and Prince and going back to the office, then when he gets back to the office, he is at a work location. I suppose a more informative hypothetical, if I may, would be, let's say the accident occurred when we got back to his base of operations.
Isn't the
If he's-
work location more bigger when you're a supervisor as opposed to a confined work area that a worker is going and saying, fix this pothole? As a supervisor, aren't you restricting work location too much? I mean, his job is to go out and make sure the roads are safe and that the kids can get to school and the buses can go. It seems like the work location is pretty vast.
Well, unfortunately, what happens then is you no longer have the distinction that the statute lays out. You no longer have any way to distinguish between whether he's actually engaged in highway work or whether he's traveling. And the third department in the Sullivan case, as we mentioned in our brief, they were certainly able to do that. They looked at what was going on with Mr. Wieland, who was the supervisor in the municipality. Their practice for supervisors was, once you leave your job site, you go to another job site to make sure that that job site was left in a safe condition.
Well,
That's
do
what he
you-
was doing when their accident occurred. So
Do you
We-
think that we should take into account public policy issues? Because if he didn't go out to check the roads, the plows wouldn't go out, the roads wouldn't be clear. Isn't that something that we should consider when viewing this case? Because if he doesn't go out, none of the work gets done.
Well, if I may, I think that sets up a false choice, because the choice is not that he never goes out. The choice is that when he goes out, we look at what he does when he goes out, the same way we look at any frontline worker who's driving a snowplow or driving a mower or a street sweeper.
Let's say his duties were go out and check the roads, all the roads, and see if there's dangerous conditions, requiring us to take, and he's driving on the roads, and he's on his way back, but he's still doing that. Why isn't that covered?
That would be a different hypothetical. That would be a different set of facts.
That's why it's a
In fact,
hypothetical. But what would happen in that case?
Well, if his testimony was that he was traveling a specific route and he had stopped at several locations to check road conditions, then it would depend on where the accident happened and what he was doing at that time.
So a kind of a fact-specific analysis again, but let's say in the policy context, these facts, except he's coming back and he looks and he knows he's passing an elementary school and he sees a hazardous condition and he looks to examine that condition because there it is. Now, if he's not engaged in this work, we just want him to go to this one location you said and then put your blinders on and go home, go back to your base, because otherwise you're not covered. Wouldn't that be a negative policy implication here?
It wouldn't, in the sense that he has already said, he had testified in his deposition, that the orders that he gave from the location of Kings Ridge and Prince would be completed within an hour. So all the roads in the town would have been salted within an hour, and
Let's say
that
in
would,
my hypothetical, where you see a hazardous condition in an elementary school, and you're on your way back, you've done all these things the way they were done here, you've done everything the same, except now you look over and, wow, is that a bad condition on that elementary school where children will be going to school shortly? Should he just not look there, keep driving, because it might be hazardous for him to do that?
I was getting to that, because that is actually in fact what has happened, and if I may answer the question.
Yes.
He knew that the elementary school buses were not leaving until 12 noon. He gave his order at about 10 a.m. His order was going to be completed by 11 a.m. There was no reason for him to take any emergency actions, and he knew that when he saw that other slush at the incident, at the location of
But
the
my
incident.
hypothetical is he does not know that. He's going by an elementary school and he sees this. What about that case?
It's really hard to answer that without knowing the facts that we have here, which is at 12 noon, the buses are going to leave, and that the roads are going to be salted, including that location where he saw the additional quarter-inch of accumulation an hour before the buses leave. So in that sense, there was no emergency, there was no reason for him to have to take additional action. And that is, again, why he was traveling between work locations. If there was some reason that he had to take that emergency action, then it might be a different set of facts. But he knew that the buses were going
So
to.
I'm sorry, let me follow up on this. If indeed one would objectively look at that and say, he didn't need to take emergency action, it could have waited a little bit, but he chooses to do so. And in the course of choosing to do that, to take emergency action, he has the accident. What about that case?
Well, again, that's a different set of facts, because he didn't take
Yes.
emergency action. In other words, there's nothing inherently necessary about proceeding into an intersection without looking to your right in the direction of the school, which is only 500 feet away. There's nothing necessary about pulling straight into the intersection without looking to your right. And there's nothing about that was done because there was some emergency action
Let's say
he
he
wanted to
sees
take.
it and he decides, you know what, I'm going to pull over and I'm going to take some action, even though I have a window of opportunity. I'd rather do it now, and then when I get back, I can handle other matters. And in the course of this, he has the accident.
That would certainly-
Doesn't he have the discretion to decide whether or not to act in the moment?
Oh, he certainly does have that
Okay,
discretion.
so and if he does that,
But that's a
not been
critically-
engaged in work on a highway?
It might be, but that is a very different situation than what we have, because he did
No, I
not make that
understand that.
decision. He did not feel that there was anything necessary for him to do. If he had remained stopped at the stop sign
Mm-hmm.
and got on his radio, the incident wouldn't have occurred, because Ms. Oriana would have passed safely through the intersection. So it's a critical difference.
Real quickly, before you exit the stage, what can you tell us that the record shows about the time that elapsed between when he observed the snow accumulation down at the second location and when the accident occurred? What's the interval between those two events?
He said that that he radioed his base from the location of Kingsridge and Prince, and then finished that radio communication from that location, and then 5 minutes later had the accident.
No, Kingsridge or High Ridge? So he observed a second accumulation of snow. I thought that was on
At
High Ridge.
Correct, yes, you're right, I'm sorry.
Okay, so it was 5 minutes between when he saw the snow on High Ridge and when the accident occurred?
No, he saw the snow on High Ridge just before the accident occurred, because he was
Moments
at High Ridge.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Brendan Fitzpatrick, counsel for the respondents. Your Honors, the Supreme Court and the Unanimous Appellate Division found that VTL Section 1103B applied to the facts of this case and dismissed this case, and I would ask this Court to affirm. Now, at the time of this incident, Michael Simone was the town of Carmel superintendent of highways, and his sole purpose on the morning of the incident was to go out and check the roads.
Can I ask you, if he had said that he was done for the day, when he was driving and noticed the snow. Would you agree that the exemption would not apply, but instead he would have been traveling to or from the hazardous location?
Yeah, if I may, Your Honor, can I
Please.
just ask, just for a little bit of clarification? Now, when you say he was done for the day and then he saw the snow,
Yes.
so again, it's not, he's just basically driving around and then he sees some snow.
Now, let's say he was out performing his job, and then he understood himself to have finished whatever he had to do. He'd called in whatever orders he needed to call in, and he is driving, wherever he's driving, back to the office, to his home, whatever, but he testified that he was done for the day, and then an accident occurred. Would you agree that that there would not be an exemption under that circumstance?
I think there's a closer call for that and probably a factual issue, but I think,
So I'm just
under
trying to
under
understand
that
what
hypothetical.
what meaning do we assign to traveling to or from if we rule for you? What exactly in the record confirms that he's actually, performing his job as opposed to going back to the office, given that I think he testified that he was on his way back to the office?
He did. But at page 151, in response to questioning, he said he had been inspecting the roads for the 20 minutes before the accident. So he wasn't simply, at a moment in time, he made his one determination, and then that was it. He was done for the rest of the drive.
But if
back to
he
the
had
office.
indicated that he was done and now he was going back to the office, there would be no exemption, right?
Your Honor, I think that's a little bit of a closer call when you look at the ruling from Briley from this unanimous court. The courts, in looking at the legislative intent, said this is to be a broad exception. And I think that would be a closer call
So
under your
if you have a
hypothetical.
supervisor who is driving to the office in the morning on the way to work and sees, a bunch of snow on the side of the road, and when she gets to the office, she puts in an order for a snowplow, would that be covered?
Again, Your Honor, I think that's a closer call. I think
Okay, but
it's-
I'm
it's-
looking for some guidance about what you think the parameters of
Right,
the
but
rule
I
would
believe
be.
that would be probably a factual issue to go to a jury, as opposed to the situation like we have here, or even like that you had in
But
some.
what would the jury then take into consideration to make the determination? What more do you need to know?
What more would you need to know? You would need to know what the normal conditions were. Was there, like this case, an imminent snowstorm coming? Was this something that the supervisor did on a normal basis, whether they were looking for snow conditions on their way to the office? Things of that
I'm
nature.
asking because I'm trying to understand if you have a supervisor, understanding that they perform a very, vital function, but if you have a supervisor who is out driving around either before or during the workday, and they see some condition on the side of the road, even if they had not set out to inspect, is it your view that the exemption applies, or is it a little bit narrower than that?
I think, again, Your Honor, I think it's on a situation like that, it's probably going to be a question of fact as to what the supervisor's normal course of actions were during the course of the day. Again, when they're looking out, when they're inspecting the roads, especially in this case, when you have a snowstorm coming, and he's out there specifically looking at the conditions of the roads, yes, I think it would, I think in this case, it falls squarely within, especially under Riley and the broad exception.
But in this case, did he not testify that he had finished his task, he had completed the observations before he goes to the stop sign?
But I
Then he's
think,
completed that task. What he's going to do with the information, the knowledge he's gathered from this observation is a different story, but he's completed that part of the work on the road, even under your analysis. I'm having problems seeing, once that's finished, he's at the stop sign, now he's going through, and he has the accident, how that's still engaged in work on highway.
Judge Rivera, you're talking about when he was on Kingsridge or when he was at the intersection?
When he's at the intersection,
He's
he
at
has
the
the accident.
Your Honor, I think, again, we're asking the courts to second-guess what these municipal supervisors are doing, and when...
No, I'm based on his testimony.
Based
I'm
upon
not-
his
I'm no second guessing, his
Right,
testimony.
But based upon his testimony...
Yes, I saw it, I observed it, I then intended to do something when I got to the office.
Exactly. He
Is
said,
he still, what else is he doing when he goes through the stop sign that's engaged in work on highway?
Again, Your Honor, the conditions that he is inspecting at the time, whether it was all the way up to Kings Ridge and all the way back to the office. That's what he was doing. That's what his job was that day. And it was a continuation.
Well, I'm sorry, I misunderstood, I'm sorry. I thought your argument was he was engaged in work because he was observing this particular problem. Now you're saying he observed that problem, and then as he's going through the stop sign,
No.
he's still observing other problems?
I don't believe that there's any testimony that he was not going to continue to inspect the roads. That's
So
what
what
his job was that
testimony
morning.
is there that he was still inspecting the roads at that point, as opposed to done with the inspection and simply returning to the office? Is there something in the record that you can help us with there?
Again, I think Your Honor's, pages 130, 131 of the record, when he sees it, his immediate reaction was, I need to go make sure that someone addresses this. And this was the first thing he was going to do when he got back to the garage, his office. So I think it's part and parcel, and I don't know.
Well, he didn't, when he saw the High Ridge accumulation, he didn't do anything about that, right? He didn't call it in the way he called it in when he was on Kings Ridge, right?
Correct, Your Honor.
So, and my sense of what was going on is there was nothing for him to do. He had already made a call, he deployed all his, I think it was 35 employees to do the town because he was satisfied by what he saw up on Kings Ridge that it needed to get done. Was there anything left for him to do at that point?
Yes, Your Honor.
Which
Because
is what?
as he sees this condition, he understands that there is a school 500 feet away.
Yeah.
He understands that within an hour, there's going to be a snowstorm hitting. And he also understands that probably within an hour, school buses are going to start taking the kindergarten children out of that school. Therefore, with the garage only about less than a quarter mile away, he knows that the first thing he does when he gets back to his office, he needs to go and tell someone to immediately remedy
Right,
this
but
area.
that's the point. He's at the intersection, he makes the observation. Let's assume for one moment that is engaged in work on the highway. That process of I stopped, I saw, okay. But then he makes a decision that I'm going to follow this up back at the office, and that's where he's going. I don't see once he goes through the stop sign, once he makes that decision, that he continues to be engaged in work on the highway. That is what I'm having difficulty with.
How long after he observes the condition does he get in the accident?
I think it's within moments. I believe there was no question as to how long were you stopped at the stop sign. There's no debate. He was stopped at the stop sign, but no one followed up with a question.
So let me give you a very different hypothetical. He's driving to dinner on a Saturday night, and there's a dead deer in the road, and he stops to inspect it, and somebody rear-ends his car, and he didn't stop. He stopped his car in the road. Covered?
So he's, okay, I believe that's a tougher question for the
That's why we
defense.
ask these questions.
know,
We're
I
still
know,
looking
Your
for answers.
But I think, again,
Does it matter that it's a Saturday, that he's not actually at work, and that when he set out, he was setting out to go to dinner, not to inspect the roads?
I think that's a factor that's definitely going to weigh against the municipality. But again, going back to Riley, this court said this is a broad exception when supervisors are out there, when they are doing work. There has to be the
So is he ever not working because he is a supervisor?
No, I think I'm sure there are hypotheticals that could be asked that, yes, he was not working. But when something is directly related to road work,
When he sees the dead deer, does it make any difference if, in one circumstance, he gets on his cell phone and calls it in right then, and the other, he thinks, this will be okay till Monday, I'll call it when I get to the office at Monday? Does that make a difference to coverage?
but is there a stop or there's no stop?
No, there's an accident
There's an
either way, yeah. Nobody cares about the community if there's no accident.
Your Honor, I think it's a tougher question. It probably would not be covered under 1103B, but
Either way, that is, whether he calls it
I
in
think it's-
now or he calls it in later, it's still,
I think the calling in later, because it's going to happen on Monday and it's a Saturday, I think the attenuation of time is significant, whereas here, I think you're less than a quarter of a mile away, and he knows that with the storm coming, freezing temperatures, he needs to get people out there right away.
So if I can be clear as to the way you view the application of the statute, if he gets to a stop sign and had not observed anything, and he's just going through to go to the office, is he engaged in work at that moment?
With his testimony that he's been inspecting the roads for the 20 minutes before
The
the accident.
testimony as it stands, I haven't changed anything else.
Yes,
The only
I think-
change is that he didn't observe the accumulation, that he was later going to
I
report.
believe he's still covered because
How-
his
So
testimony.
then your answer to Judge Troutman would have been, yes, he's always working.
No, I don't believe he's always working. This was a specific morning.
But in Judge Rivera's hypothetical, why is he not traveling to or from the hazardous operation at that point in time?
Because his testimony is that for the 20 minutes before the accident,
Yes.
he is inspecting. He may have
Yes,
given an order,
but-
but he's continuing to inspect. Sorry, Judge.
Well, maybe that's the crux of the question, right? If he has determined that his inspection is done, and he is heading back to the office, and he happens to see something, just like you or I would see something driving down the road, there's some snow or ice over there, is the fact that he holds the job sufficient to allow him to claim the exemption? I mean, you or I could be driving down the road and see whatever the weather situation is on the side of the road. Is he like us when he is not, when he doesn't view himself as in the middle of an inspection task, or does he have some different status?
No, I think as the supervisor performing this work, he is a little bit of a different status. He is performing work on the roadway.
So
and-
any supervisor who's out driving around, maybe at any time, maybe just during the workday, if she sees something, dead deer, patch of ice, snow, that's sufficient to invoke the exemption?
I think it's sufficient to invoke it. Whether the municipality is going to be entitled to summary judgment on the issue, I think is a completely different.
Can I just ask you, getting back to this policy discussion that some of us were having with your adversary before, does the town take the position that Mr. Simone wouldn't have been acting within the scope of his duties if he's not entitled to the 1103 protection, or are you satisfied that he's doing his job regardless?
I believe he's doing his job. He's doing his job, and I'm not sure I understand the question. Justice
Basically, I'm asking, he's going to be indemnified under, or he's going to have respondeat superior coverage, whether he had the 1103 protection, or he was just subject to the regular rules of the road, right?
Yes, he was within the course of his employment. There's no debate about that.
Okay, that's all I wanted to know.
Yes, but, and then, again, getting back to, I think, Riley against County of Broome, that's the controlling case for this matter. And in writing for the unanimous court, Judge Case said the legislative intent, not just simply the statute, but she went back beyond that and looked at the legislative intent and said the legislative intent is to create a broad exception from the rules of the road for all vehicles engaged in highway construction, maintenance, and repair.
But there's a last part of that quote, right? Regardless of classification.
Yes, regardless of
And I think that was something of a specific issue in that case. The problem I'm having with some of your answers to the hypothetical is, I think Chief Judge Kaye also says this is something of a balancing, because you have a need for these vehicles to go out in hazardous conditions, which may in itself create a hazard. And courts, she notes, have struggled with striking that balance. The statute was a way to strike that balance, and I think if you overread, particularly by cutting into that quote off, that broad language, you swallow this exception up and you unsettle that balance.
I'm not sure, Judge Garcia. I think when numerous of the examples and the concerns that were raised when the initial legislation was created, and Judge Kaye noted in 95 New York 2nd 468, there were concerns. Why, for example, should rural letter carriers and tow truck drivers be permitted in the course of their work to speed, drive on the wrong side of the road?
Right.
And
That's a tow truck, so
Yes.
the classification really shouldn't matter if it's a tow
Right.
truck or if it's another vehicle, and I think that's what she was
Right,
talking about.
and in
classification.
response, this court wrote, apt those concerns may be, the legislature has spoken clearly, giving vehicles engaged in road work the benefit of the same lesser standard of care as emergency vehicles. Any change to that standard, therefore, must come from the
Right,
legislature.
and I think what she was getting at, though, and I'm not arguing with you over broad in a sense, but I think that particular point was classification as an emergency vehicle or a tow truck or in this case, someone driving their own car, that classification doesn't matter, right?
But this was a town car.
Right,
It wasn't his own.
but it doesn't matter, it's the
Right.
function.
But
But you seem to want to expand that language to a blanket, broad interpretation of the statute so that it fits into, a deer on the road when someone's going to dinner.
Your Honor, I think on those hypotheticals, I definitely think it is more of a question of fact, but on these facts, when he is engaged in the work, without his, as I believe one of the judges said, without his inspection and without his instructions, these guys don't go out and maintain the roads.
Thank you.
Thank you, Your Honors. I ask this court to affirm. Thank you.
The reason that we're asking this court to reverse the decision by the Appellate Division, Second Department, is because we believe that it sets at the very least an unclear and possibly even consistent or inconsistent or contradictory precedent with regard to the Sullivan case in the Third Department. Because in the Sullivan case, the analysis is the same as the analysis is in all these other cases. What exactly was the municipal employee doing at the time of the accident? Was he actually engaged in work on a highway, or was he traveling to or from a work site? And in this decision by the Second Department, they do not discuss at all the exception to the 1103B rule of if he was traveling, he's not covered by 1103B. If in fact, and they also do not discuss anything that we've discussed here today about what Mr. Simone was doing, about his inspection.
But you agree that if he's, in the course of traveling back, right, traveling back to his office, if he had actually testified, I had finished with my observations at the Bellwether, I was on my way back, I was going to end the day, and I continued to observe the roads on my way back. You agree that might very well result in the exception applying?
Well, we would not expect any highway worker to drive with blindfolds on so they don't see anything other than what's directly ahead of them. So I would say no, in the sense that the task he set out to perform when he left his base of operations was, in his own words, when I asked him at the deposition, were you going to follow a particular route? Were you feeling your way along? He said, no, I was going to Kings Ridge Road. And I asked him specifically an intersection, Kings Ridge and Prince. I was going there. It's one of the highest elevations in town. That's where the snow is going to accumulate first. And then when I said to him, I asked him the next question. So before the accident, when you were on your way, where were you coming from? Were you coming from your office? He said, no, I was coming from Kings Ridge. So he clearly thought that he went from his office to Kings Ridge, back to his office.
So then that's a yes to my question, right? That if indeed he had said, I finished at the Bellwether, I was on my way back, and I was continuing to observe the roads as I went along. Your answer is yes, then, yeah?
He never said that. But
Correct.
In your
That's why I
hypothetical, if he
correct.
had said that,
Yes.
it would be contradictory, and it might actually require a trial by jury to determine whether he was actually traveling because he said he was on his way, he was looking at the roads on his way back, or whether he had completed his task, which was in fact completed when he radioed from the Kings Ridge location, told his men to go out, and actually said on...
Isn't the person tasked with that job the one who decides whether or not what they've finished at the Bellwether is enough? If he is saying, I finished what I wanted to do at the Bellwether, and I was continuing to observe the roads as I went back.
Okay, but that is not what he said, and when I asked him specifically
We're getting nowhere.
on page 85 of the record, had what you had done at the Bellwether location addressed the conditions as you saw them at that time, he said yes. On page 92 of the record, I asked him the same question. Was there an emergency situation? No. Were you in a particular rush to get back to the office? No. So we would ask you to please reverse the appellate division and grant summary judgment to the plaintiff in this action.
Thank you.